Mr David Shoebridge.
Madam Deputy President, I rise on behalf of the Greens to oppose both the Evidence Amendment, Evidence of Silence Bill and the Criminal Procedure Amendment, Mandatory Pretrial Defence Disclosure. The fact that the Greens would oppose the removal of the right to silence, in part or whole, has been a matter on the public record since the government first made this announcement last year. And since that time, the government has engaged in a wide-ranging process to seek to remove a series of fundamental restraints on police power and fundamental protections for defendants in criminal trials, which have now culminated in the proposal supported by the current Attorney-General to not only remove the right to silence, but also to remove one of the fundamental principles from the criminal justice system, that is that the prosecution has to prove its case, and citizens who are brought before the courts on criminal matters are not required to prove their innocence. And it's hard to imagine a more fundamental attack on the basic workings of our criminal justice system than what is being proposed by the government under the guise of dealing with bikies and under the guise of making criminal trials more efficient. Of course, criminal trials could be more efficient. They could be done more quickly. They could be done very rapidly. Other jurisdictions have very efficient criminal trials. Soviet Union used to have efficient criminal trials. North Korea, I understand, has very efficient criminal trials. China, I understand, has very efficient criminal trials. But the Greens have always stood for the rights of citizens in a free country to come before a criminal justice system which respects their fundamental rights, which respects their right to silence, and which requires the prosecution, through the state, through the prosecution, to prove the case, and does not compel citizens to have to prove their innocence, as is being proposed by the O'Farrell government. Before the removal of the right to silence, as being proposed by this government, will, as anyone who actually looks at and studies the criminal justice system know, will affect the most vulnerable in our society. It will not have a significant impact on those well-heeled defendants, such as criminals in bikie gangs, criminals in drug dealers, who will have access to, as they do, extraordinarily expensive legal counsel. The people who will be most affected by these changes will be the most marginal. And we know who they are because we see them time and time again in the criminal law stats. They will be Aboriginal members of our community. They will be people of lower socio-economic standing in our community. They'll be people with poor educational outcomes. On average, they'll be people with an IQ substantially below the average IQ of citizens in New South Wales. They're the people who will have the right removed from them without adequate legal protections and without adequate legal resources to deal with it. And it's important to understand that the right to silence is not simply a right that criminals choose to exercise to avoid being found guilty. It's a right that all of us should have in a free society when faced by intrusive questioning from the police and from other prosecutorial officials. The government isn't planning to remove this right from criminals. The government isn't planning to remove this right from bikies. The government is planning to remove this right from everybody. And it's remarkable, as time and time again happens in this chamber, that a notionally conservative government is proposing to make such a change to a fundamental part of the legal system. The right to silence came about when individuals and society began to balk at a practice that had developed in England in the 14th, 15th and 16th centuries, where star chambers and ecclesiastical tribunals regularly resorted to torture and physical punishment to force confessions from defendants. And in response, the common law, to its credit, developed principles and rights that protected individuals from the oppressive use of state and, at the time, church power. And in fact, one of the most respected legal thinkers, and normally respected by conservatives, as well as by those people concerned about civil liberties, was Blackstone, who some 4 centuries ago said this: "It's only by a firm adherence to the rule, as so stated, that effect is given to the policy of the common law, that a suspect's fault is not to be wrung out of himself, but rather to be discovered by other means and other men." The rationale behind the right was more recently restated by the High Court, the majority of the High Court in Petty and Maiden and the Queen, a 1991 High Court case, where the court said this: a person who believes on reasonable grounds that he or she is suspected of having been a party to an offence is entitled to remain silent when questioned or asked to supply information by any person in authority about the occurrence of an offence, the identity of the participants and the roles which they played. That is a fundamental rule of the common law, which, subject to some specific statutory modifications, is applied in the administration of the criminal law in this country. An incident of that right of silence is that no adverse inference can be drawn against an accused person by reason of his or her failure to answer such questions or to provide such information. To draw such an adverse inference would be to erode the right of silence or to render it valueless. And that's exactly what the government's proposal is intended to do here, to render valueless the right to silence that I hear the Honourable Fred Noel chirping up about in the corner.
Still have the right to silence.
The most recent independent review of this issue was undertaken by the New South Wales Law Reform Commission, and we heard from the Honourable Trevor Khan some contributions about the New South Wales Law Reform Commission. He just forgot a few things about their report in 1995, report number 95, on the right to silence. That review, which was far more extensive than the current, than the most recent review the government has done, firmly concluded that the right to silence should be maintained and not eroded in any way, shape or form. The Law Reform Commission identified a number of concerns within those jurisdictions where the right to silence has been modified. Notably, that it's likely to reduce the overall efficiency of the criminal justice system, as well as allowing negative inferences to be drawn from a defendant's silence in many cases where the inference is unjustified. They identified a series of reasons why removal of the right to silence, in whole or in part, would produce negative outcomes. And indeed, there are many reasons consistent with silence why an innocent person would, consistent with innocence, why an innocent person would exercise their right to silence. And these are just some of the reasons the Law Reform Commission found why innocent people exercise their right to silence. The first is that certain groups in society have attitudes towards police, such as a generalised fear or mistrust. That would include members in the Aboriginal community, many migrant groups who come to Australia from jurisdictions where the police are considered with fear, and for good and proper reason. Another is cultural characteristics which may lead suspects to remain silent, particularly in relation to subjects involving domestic abuse and sexual assault. The Law Reform Commission also said that characteristics of innocence, such as personal characteristics including gender, age, mental disorders or acquired brain injuries, are often entirely valid reasons to exercise silence consistent with innocence. Others were communication factors such as language skills, impairment by alcohol or even tiredness. When you're being questioned at 2 a.m. in the morning and the police have dragged you out of the bed and have continued that questioning from 2 a.m. in the morning through to 6 a.m. in the morning, you're potentially facing the most serious consequences in your life. The exercising the right to silence would be considered by most citizens to be an entirely appropriate action, yet this government wants an adverse inference to be able to be drawn from it. Another reason the Law Reform Commission put forward was police disclosure, meaning the extent to which police may put matters to a person. This can be highly variable and will depend on the stage of the investigation and even the familiarity of the questioning officer with the relevant facts and law. Other reasons are protection of or fear of others, and finally other reasons including difficulty remembering distant events or serious emotional disturbance at the time of questioning. As identified more recently, there have been a series of statements from the Law Society, from the Bar Association, from almost any credentialed legal academic about the right to silence being a fundamental part of our legal system which should not be removed. In fact, it's often said that the right to silence is part of a package of rights that protect people from being forced to incriminate themselves. And in fact, some legal scholars now view it as a single right against self-incrimination which has a variety of forms. And such a right only has effect and can only be given full force of the law when not speaking, that is, exercising your right to silence, cannot be used against you. The proposed change in this bill has that potential to change those fundamental elements of the criminal justice system, going so far as shifting the burden of proof in practice. As Mr. Dow, as the former Honourable John Dowd said on this issue, the right to silence is an essential tenet of the criminal justice system. that the prosecution has to prove its case beyond reasonable doubt. It is not the responsibility of the accused to prove his or her innocence. Those are the principled reasons why the right to silence, the removal of the right to silence should be opposed. But there are fundamental practical reasons why this government's proposal should be opposed. And that is that it will almost certainly lead, if this becomes law, and one hopes it doesn't, to even less cooperation and even less disclosure by those being questioned by police. When you talk to members of the criminal bar, when you talk to those who work in the criminal justice system, they recognise that, as drafted, this bill will actually lead to less people answering police questions, because the adverse inference can only be drawn against an accused person if their lawyer is present during police questioning. Now, the presence of a lawyer would be essential in order to protect someone's rights and liberties. I mean, that is, if you are going to remove the right to silence, you would insist on having a lawyer present. But in practice, how does that compromise work? Well, it works very poorly, because if someone is facing serious criminal questioning about a serious criminal charge, potentially facing questioning about armed robbery or some other serious indictable offence, they call their lawyer up and say, "Can you come down to the police station, please? I'm being questioned about an alleged armed robbery or an alleged serious offence." It would almost be professional negligence for the lawyer to attend upon the police station and assist in the questioning, because it's only on the attendance of the lawyer that this new regime would kick in. It's only if the lawyer goes to the police station and seeks to represent their client that their client is then exposed to the adverse inference, because the adverse inference cannot be drawn absent the lawyer. So almost invariably, if this would become law, you will find the advice being given by criminal lawyers, whether it's from the Legal Aid Commission or private lawyers, will be, when they get a call from their client, "I'm down in the police station, I'm being questioned on this matter, what should I do? Can you come down here and give me some advice?" The lawyer would almost certainly say, in fact it would probably be professional negligence not to give this advice, "I'm not coming down there, you don't want me down there, if I turn up, it's only if I turn up that you can have negative inferences drawn against you about your right to silence. You're much better off say nothing, make no comment, answer no police questions, and I won't come down and I'll see you again later." And that's going to be the practice. This won't end up with producing more disclosures. This won't end up breaking down the wall of silence. This is going to concrete the wall of silence. This is going to guarantee that people don't cooperate with police questioning. This is going to make matters much worse for police. And even if you accept the unprincipled arguments the government puts forward for getting rid of the right to silence, on a practical level, if they really want to have increased cooperation with police, this bill is nonsense. This bill works directly against the interest of having people cooperate with police. And that's true for the innocent as it is for the guilty. The second cognate bill that the government's moving is the Criminal Procedure Amendment Mandatory Pretrial Disclosure Bill. This is a bill that effectively requires the defence to put on notices proving their innocence, why it is they say they're innocent before the trial starts. And as the government notes, they put this proposal to the Trial Efficiency Working Group, which they hastily convened over the Christmas holidays. And when they put the idea of mandatory pretrial disclosure to that Trial Efficiency Working Group, every member of that group, except for 2 Supreme Court justices, opposed these proposed changes. Every member. The DPP proposed these changes. I mean, the prosecution itself is saying they don't want this. And it's the prosecution, the DPP, who carry the burden of actually running this proposed change in our criminal courts. When the DPP are telling the government they don't want these changes, it'll make it less efficient, it'll create increased burden, it'll slow down the courts. Why would the government then come forward and insist on the changes under the guise of trial efficiency? The prosecution don't even want it. They've told you they don't want it, and you're just ignoring the advice from the DPP. Not only that, the busiest jurisdiction, the busiest criminal jurisdiction in the country which deals with indictable offences, the District Court. The Chief Judge of the District Court has come out plainly and said the District Court doesn't want this. The District Court understands that these added layers of complication, these added pre-trial procedures, are going to delay matters getting heard. They're not only going to delay trials coming on, while the prosecution and the defence have argy-bargy over the extent of the disclosure. But then once the trial starts, the experience in other jurisdictions where they're put on these kind of comprehensive pre-trial disclosure statements means that trials get constantly interrupted in the course of running them by voir dires, trials within trials, where you find the defendant's solicitor is being cross-examined in a little internal trial, absent the jury, about what the defence solicitor knew at the time they put the pre-trial notice on. When did they get the advice? What did they mean by that? And days and days and days of trial court time is taken up with not dealing with the substantive charge, not dealing with the crime which is being brought before the courts, but days and days and days are spent up running these trials within trials about who said what in the disclosure, when the solicitor knew the disclosure. And of course the district court doesn't want that. The district court's busy enough. It's busy enough trying to deal with the actual trial. They don't want to have then 10 mini-trials within that trial about whether or not the disclosure provisions have been complied with. And of course the Law Society and the Bar Association say the same thing. In some ways it would be in the interests of the members of the Law Society and the Bar Association to have these kind of nonsense provisions put in the criminal justice system. Because there's more work for lawyers in this, there's more billable hours for lawyers in all aspects of it. But on a principle basis, the Law Society and the Bar Association join with the DPP and join with the District Court and say these are seriously negative changes being proposed. They won't work. They will work dead against the objects of the government about trial efficiency. Yet we still find them being pushed in a bloody-minded way by this government because they want a headline on bikie crime and they want a headline about so-called breaking the wall of silence. These changes, together as a package, are wrong in principle, they're wrong in practice, and the Greens will be opposing them.